This case from supplementary list item 1, first appeal 43 of 2012.
नोटिस देंगे वो 4 बजे नहीं होता ऑर्डर स्पेस हम लोग करेंगे 4 बजे सारा रिकॉर्ड
Yesterday I had completed part of the claim PW1 and your lordships exhibits
I
1,
just
2,
one thing I want to one
Two
query
more.
on facts. One query on facts. As per the claim, there were 6 owners.
yes, sir.
Who was the zamindar of the entire mosque?
That has not come anywhere. That has not come anywhere. Some of their witnesses have gone to the one of the witnesses.
Witness तो नहीं हुआ ना. Who was the zamindar of the entire mosque?
Nowhere it is.
Right to witness.
Because I was also trying to find out. If 6 Anna was with us, then 10 Annas will be with the Jamindar only.
The exhibit list.
Yes.
थोड़ा देखते हैं written statement में.
जी. But our application filed under order 1 rule 10, that was treated as written statement.
Just a minute.
Where is the lordship got?
Written statement on behalf of victim number 3.
No, it is petition filed on behalf of Datta. So under order 1 rule 10, that the learned court will say that we'll treat this as
कहाँ चला गया? ये डिफेंड नंबर 3 कौन था?
defendant number 3. It is the society.
अच्छा.
Who is the
Order 1 rule 3 का petition था.
order 1 rule 10 का है. Because we were not with parties, we have
Yes,
to
yes,
interpret.
I remember I've read it. In fact. तो देखिए तो ऑर्डर 1 रूल 10 का कुछ पिटीशन इसका पड़ा होगा मिसलेनियस सिस्टम का. लेकिन फ्लैग किया होगा तो सारे फ्लैग किया. नहीं. Order 1
We
rule
had
10.
provided a copy, Lordship, last time.
You had provided a copy.
Yes. That was.
क्योंकि हम लोग पूरा ही पढ़े थे. आपको
Ah,
याद है?
no question. It was not in Lordship's file.
अच्छा प्लेंटिफ से पूछेंगे. वो अपना केस बेस करेंगे. चलिए. ठीक. You are done.
Therefore, lordship, till I am not taking your lordship to all the cell certificates.
Okay.
Similar language is there, your lordship. If they point out something, lordship will give us that. So,
So description is absolutely vague.
Vague.
Property is
that was
unidentifiable.
the first ground. Second ground is the lordship. Second ground is the lordship. The plaintiff do not disclose. Lordship, what has actually followed from the lordship? What lordship they admit in paragraph 3. So I'm just reading out of the plate. That Sashivala Dasi dies issueless and 2 anna interest of Moja along with other lands were inherited by Chandra Mohan Datta. I yesterday said there is no explanation how her entire land can be because there were 2 other brothers, even if she is issueless. There were 2 brothers, Chandra Mohan Datta and other brothers, both will get. There is no explanation. This beside Lordship, there were other lands also. Now in Lordship, para 3 Your Lordship of the plate.
Okay, the learned counsel for the respond number
I am respondent number 10 to 15.
10 to 15 has referred to paragraph 3 of the plate to submit that it is not clear how upon death of Sasiwala Dasi the entire property could have been inherited by Chandramohan Datta, as Chandramohan Datta had also full brother.
No, Your Lordship.
Full brother from
2 anna shares Lordship each Chandra Mohan Datta, Surya Mohan Datta and Sishtida Datta had 2 anna each. Therefore 6 anna as per their pleadings. Lordship, Sashivala Dasi is widow of Sishtibadhar Datta, the third brother. So if she dies issueless, then Lordship there are 2 branches, Chandra Mohan Datta's branch and Surya Mohan Datta's branch alike. So even if their story is believed, then her share will devolve upon 2 other branches.
it is not clear as to how the entire property to the extent of 2 anna interest of Sashiwala Dasi devolved only upon Chandramohan Datta.
And Lordship, there is
Although-
no evidence also.
There were 2 other branches. There were altogether 2 further branches.
Further branches, yes.
Good, yeah.
Next, Lordship will take into consideration that in the plate, there is no clarity that Lordship, suppose we accept their story that 6 anna was purchased by them. Which is that 6 anna that it is not there? Lordship, besides 6 anna, what were the other lands? This is one. Secondly, Lordship, when the land has vested under vesting of Jamindari, Lordship, under the Land Reform Act, Lordship, how much land, Lordship, was under tenure or intermediaries, which Lordship vested and they got compensation against the right to collect. How much land in Lordship which they did not retain? Lordship, the Jamindari Lordship has seen the definition. It includes forest rights also, it includes cultivable rights also, it includes right to claim rent also. Lordship, the compensation is paid with respect to Lordship right which they surrender, with respect to right to claim rent, right to everything. And Lordship, they can return some property as a rayat. So how much property they had actually surrendered, which could have been possible. Therefore, my learned friend was also insisting that that can be clear only from the Form K. That this is the land which we are retaining and this is the land which we cannot return under the Act. Therefore, we have to surrender it. Also, that has not been brought on record, and there is no pleading to that effect. Hardless evidence.
Form K would have only 3 kind of properties. One is to be retained by the zamindar
Yes.
as rayat for the state. The second would be the already rayats who are there.
Rayats, yes,
And
Lordship.
third will be a third category like forest, or
Forest,
maybe
government land, or the
Sariyat,
excess land which I
or
cannot.
common land.
Common land, yes. Because evidences have come, Lordship.
In absence of Form K, it cannot be ascertained as to how much property was retained by the plaintiffs.
Plenty. Lordship, only make a note here, Lordship. To the contrary, the Form K which we had filed, the Jamindari returns which we have filed, we had exhibited. That is exhibit. That is your also exhibit E.
Learned Counsel has also submitted that if the plaintiffs were claiming zamindari interest over the property by virtue of auction sale, it was for them to exhibit Form K to enable the court to ascertain as to what was the area which was ultimately retained by them by virtue of vesting of zamindari. He submits that. On the other hand, the defendant Dattas have filed their Form K, which has been exhibited as
Exhibit E.
which has been exhibited as Exhibit E. लाइए जरा Form K दिखाइए. Exhibit E चाहिए. वो ना हमको ऑर्डर 1 रूल 10 वाला हमको थोड़ा सा अपने जूनियर को बोलेंगे खोज देने के लिए, है ना? ये होगा ही रिकॉर्ड पर या फिर आपने तो दिया ही होगा, पता नहीं.
जी, इससे जो हम लोग पेन ड्राइव में लिए उससे प्रिंट आउट निकाल के भेज सकते हैं।
हाँ, क्योंकि ना वो कहीं लगता है होगा.
I haven't seen on that day also.
But if that is attached with the plaint and that
Yes.
would be better.
हाँ, I will just take it out at that. मिल जाएगा, कोई बात नहीं. एग्जिबिट ई दिखाइए जरा. आप बताइए क्या बोलना चाहते हैं.
एग्जिबिट ई दिखाना खाली इतना ही दिखाना चाहता है कि हम लोग जमींदारी रिटर्न फाइल किए थे।
When did you find it?
It was filed. Case number is indicated 391 of 5657.
एग्जिबिट ई जो है यहाँ पर
Actually, it will be a
डिपेंडेंट
long-
नंबर 3, राइट?
Yes. It will be a long document, a big document.
It's a detailed order. This is the order dated 10/2/2009. Passed
No,
in
no,
miscellaneous case number 5 of
Exhibit E is the
2009.
copy of Jamindari return as per the lordship's lower court record election list of exhibits.
नहीं, यहाँ पे एग्जिबिट ई कुछ और ही है.
So we have marked it lordship from the lower court records.
Only two things. There are two separate sets of exhibits for both the defendant. So the numbers are common.
Numbers are common.
Yes, yes. Because defendant number 3 had exhibited certain document ABC.
दिसंबर डिपेंडेंट नंबर 3 का एग्जिबिट ई मिला.
ये इनका अगर ये किए हैं तो 5 to 10 का अलग.
हाँ, यहाँ पर भी है. डी सीरीज के बाद ही एग्जिबिट ई है.
जी लordship.
बहुत सारा डी सीरीज.
It is certified copy of some. It must be a folded document.
Yes, sir. Long document.
इतना रिकॉर्ड में कोई एग्जिबिट आप बोल रहे हैं, ऐसा खोजते रहेंगे तो हम
Lordship, I'll do one.
कितना टाइम वेस्ट होगा.
Lordship will leave it for the moment, lordships. I'll come to it, lordship. By that time I'll get it xerox.
जेरोक्स का बात नहीं है ना, हमारे रिकॉर्ड से ही आपको बताना पड़ेगा. हम आपके कोई डॉक्यूमेंट को नहीं देखेंगे. लिखा लगाइए अपने जूनियर को इसमें से एग्जिबिट. इसमें क्या है? इसमें तो नहीं है.
Also, you can find out.
मुझे हाँ बताइए. So you want to say that return was filed.
Return was filed by us.
Does it include all the properties involved in this case?
It includes this property and other properties also.
Okay. कौन सा खाता नंबर पढ़िए, कौन सा केवट नंबर.
Keyword number पूरा दिया हुआ 12, 22/1, 28, 7/1.
पूरा कवर्ड है.
पूरा covered है,
overlapping है and additional भी.
additional भी. Now your lordship may kindly come thereafter to PWD.
आपका फॉर्म के बाद क्या?
अच्छा मेरा फॉर्म के हम लोग जमा कर दिए थे, फॉर्म एम हम लोग का नहीं इशू हुआ था, इनका भी नहीं इशू हुआ था. अच्छा आर्गुमेंट्स हम लोग का एविडेंस क्लोज हो चुका था. अच्छा डेट वाज फिक्स्ड फॉर मार्किंग ऑफ एविडेंस. In between lordship they have filed 3 documents. They claim as per the plaint they have 5 informs. They have filed 3 documents. What is those documents without I show from the evidence? None of the witnesses have spoken anything about them. Those were marked as exhibits. That's why informs. 3 informs. 3 informs do not cover otherwise also the entire property. Now, if the learned court below, if it had to decree on the basis of 3 informs, they could not have decreed the entire suit in favor of the plaintiff. Now, Lordship, realizing that, Lordship, they, before this Honorable Court, filed an application for additional evidence saying that we will now exhibit the remaining 2 also. Lordship, we filed, Lordship, in the meantime, state government was made a party in the first appeal. State government, Lordship, that document is not exhibited, but Lordship, it is a part of the record because by the orders of this Honorable Court, state government filed an affidavit, wherein their Lordship said that these informs are not.
State government, in absence of state government, we are not going to acknowledge any affidavit filed by them.
Lordship,
That does not form a part
Lordship.
of the record.
yes, in the first appeal, Lordship, because Lordships, by the direction of this court, they filed, yes.
Maybe they are not here.
No, they are not here because Lordship subsequently deleted their name.
Mention. You deleted the name.
Yes, but previous orders are there, reports were called for.
Reports might have been called for, but they
Very
do
well.
not form a part of the record.
Now, Lordship, when they wish to exhibit 2 informs, which are being
You must have
disputed by the-
responded to that interlocutory.
We have
application.
responded to it, we have brought on record the letters or reports of the state government. Now, your lordship, the issue would be, if a document which they seek to prove, the genuineness of the document is being your lordship, seriously challenged by us, that it is not genuine, lordship, that cannot be marked as an exhibit unless it is admitted or it is proved, your lordship, by cogent evidence. Lordship, the informs which were marked as exhibit before the court below also, lordships, were not proved by any evidence. Lordship, the rent receipts were proved, for that they had reduced 1 evidence, but no informs were
Just hold
proved.
on. The learned counsel has submitted that the defendant number 5 to 10, no? Had filed their form K, which is apparent from exhibit E before the learned court. But upon the query of this court, he has submitted that form M was not issued to the defendant number 5 to 10.
Yes.
The learned counsel has also submitted that so far as the plaintiffs are concerned, at the fag end of the trial, they tried to exhibit 3 M
No, they
forms.
filed 3 informs.
They
which were
filed
exhibited.
3 M forms which was exhibited but not exhibited through oral evidence.
No oral, yes.
But not exhibited through oral evidence. And the learned trial court has passed the entire judgment on the basis of those 3 M forms. He has also submitted that when it came to light that those 3 M forms which were exhibited before the learned trial court were not sufficient to even cover the entire suit property, additional evidence has been filed by the plaintiff before this court seeking to adduce 2 more M forms. He further submits that a counter affidavit has been filed to the interlocutory application seeking to adduce additional evidence on behalf of the plaintiff, and the filing of the M form has at first appellate stage has been vehemently opposed by the arguing counsel, and he submits that the informs are disputed documents, and rather the records of the state do not suggest that such informs were duly issued. Yeah?
Yeah. Now, Lordships, coming to the PW2.
Have they given any explanation for not filing it at appropriate time? The learned counsel has also submitted that the plaintiff, in order to bring the M-form before this court by way of additional evidence, has not given sufficient explanation for not producing it before the learned trial court at appropriate stage. He has further submitted that the filing of such M-forms is an afterthought only after they realize that the M-forms already on record were not sufficient to support the decree passed by the learned trial.
Now, Lordships, coming to PW2, this is the second witness. PW2 is one Shiv Narayan Jha, whom they should have examined to show that they had possession. So PW2 says that I am a Amin, as and when I was called upon, I had gone and measured their land. Also, he further says that in paragraph 8 specifically, that the plaintiffs have about 1.20 acres.
वो तो हो गया, बहस हो गया. The learned counsel has referred to the evidence of PW2. However, PW2 का बहुत extensively हम लोग record
जी जी तो छोड़ दीजिए.
has referred to the evidence of PW2, which was already fully placed by the learned counsel for the appellant during the course of hearing, and therefore he has not repeated those submissions. He has in particular referred to paragraph number, खाली paragraph number बता.
Cross exam, first is paragraph 8,
8,
then paragraph 10, 11,
10, 11,
14,
14,
20,
20,
24,
24,
28,
29,
29,
29,
32
30,
and 33.
and 33 to submit that the evidence of
33 and 41.
33 and 41 to submit that the evidence of PW2 is inconsistent and the same cannot be considered as an evidence of possession of the plaintiffs. Okay?
And one more line, I'm not taking your lordship to that document. After we concluded the cross examination, also thereafter they filed an affidavit.
He has also referred to the affidavit filed by PW2 making certain correction in paragraph 8 of the
Only in that.
paragraph 8 of the evidence, and thereafter the PW2 was examined further.
Also, thereafter, PW3 has sent to your lordships some rent receipts. Now, your lordship take into consideration those rent receipts.
PW3.
Yes. He is an advocate clerk. He has rent receipts which have been marked as Exhibit 5 series. Now, actually, the rent receipts, there is nothing on record to connect these rent receipts with the suit land. Neither Khewat number mentioned, not plot number mentioned. Only Mauja is mentioned as Rangoli.
The learned counsel has referred to the evidence of PW3, who was an advocate clerk and has exhibited rent receipts which were marked as Exhibit 5 series. However, he submits that the rent receipts are not capable of, but there is nothing on record that these rent receipts are relatable to the suit property involved in this case. He submits that neither Khewat number nor plot number has been mentioned. What has been mentioned is only Moza Rangi.
And secondly, the plaintiff who was examined as PW1, he never came forward to prove this. So that I had obtained it for this. He was the person who might have attended.
Further, these rent receipts were not placed on record by PW1, who was the plaintiff himself. So as to cross-examine him,
He was a pro forma defendant. और जो relief suit में plenty for pro forma defendant दोनों claim मांगा गया.
who was the pro forma defendant and was directly connected with the property, correct?
Yes, Your Lordship.
And consequently, nothing could emerge from the cross-examination of PW3, who was just an advocate clerk, to relate these rent receipts with the suit property.
Now, Your Lordship, all the witnesses Lordship had seen from the plaintiff side, because none of the witness have stated anything about Your Lordship, the details which were required. That how much land was vested, how much land has been vested with the state government, how much they have written, there is no whisper of this state.
The learned counsel has submitted that neither the plaintiff nor the evidence of the plaintiff disclosed the foundational detail in connection with the suit properties.
Now, Your Lordship, they have exhibited
And
one
consequently, the entire plaint and the evidence remained vague, which could not have translated into a writ.
Lordship, they have exhibited one document, that is Exhibit 6, that is the land acquisition judgment passed in the land acquisition case, to show that our claim has been negated. Now, Lordship, there is absolutely no pleading that part of the land subsequently was acquired and compensation was paid. Lordship, the law is very well settled.
This is exhibit number.
Exhibit number 6.
The learned counsel has referred to exhibit 6 to submit that a judgment passed in the case of land acquisition case has been exhibited by the plaintiff to show that the claim of the appellant to claim compensation arising out of acquisition of land has been negatived. The date of the judgment is the date of the judgment is dash 23 and date of filing the suit
Date of filing of the suit is 2006, Your Lordship. Suit has come down. Twenty-six. Two 5/2006.
judgment का क्या date है exhibit 6
Judgment का date है 2012-2008.
But he has submitted that, but nothing has been mentioned in the plaint with regard to the land acquisition case.
Because that is the case of 1985.
However, during the course of argument, it appears that the land acquisition case was of the year 1985. The suit was filed on 2/5/2006 in the present case, and the judgment in the land acquisition case was passed on 2012/2008.
And Lordship, there is no whisper that any such litigation is pending between the parties with respect to any part and whether it complies of that 6 Anna share or not.
इस समय के 85 का सूट में क्या ही मेंशन होगा? Are they party in that proceedings?
हम
Are
लोग
they
party-
party? दोनों
they-
जने party हैं?
हाँ, हम लोग दोनों पार्टी थे, पाल से नहीं. Lordship, land was acquired, they claimed, we also claimed. Now, Lordship, there is no mention, they have exhibited this document to negate our claim. Lordship, there is no mention about those pending proceedings in the suit.
कैसे होगा? Pending proceeding के लिए नहीं mention है, लेकिन final judgment तो बाद में
फाइनल
आया।
जजमेंट बाद में आया, तो बाद में भी आया तो
You
amendment
cross-examine them on that.
Lordship,
It was when it was exhibited.
Lordship, it was exhibited
Just
after
one
the evidence
thing.
was closed. All documents were marked as exhibit on in September, 19 September 2011. Lordship, just 3 months before passing of the judgment. 12 September 2011. Lordship, when the witness does not say anything,
Without anything more, it was simply exhibited.
it was simply exhibited. Now, Lordship, I can cross-examine a witness from the pleadings or from the depositions which he has made.
The learned counsel submits that most of the documents,
Yes. Most.
including exhibit 6,
Yes.
was placed on record on 12/9/2011, and by this time The evidence was already closed.
No, we are marked as exhibit on 12/9/2011.
Marked as exhibit on 12/9/2011, and by this time the evidence
Evidence
was
is
already
already
closed.
closed.
ऐसा होता है क्या? Procedure में
Normally
ऐसा
होना
होता है
चाहिए मतलब जहाँ भी एविडेंस देखिएगा डिपोजिशन
क्या चीज़
कि एविडेंस
Portion
क्लोज
blank
हो जाने
छोड़ो।
के बाद कोई भी डॉक्यूमेंट ऐसे आके मार्क एग्जिबिट हो जाए,
मतलब इस केस में सारा डॉक्यूमेंट एग्जिबिट मार्क हुआ एक ही दिन में।
ऐसा होता है? व्हाट इज द प्रोसीजर?
अदर साइड को मौका तो मिलना चाहिए, लेकिन इस केस में दिस वाज बिकॉज दिस वाज अ जजमेंट पास बाय ए कोर्ट,
Is it
therefore
a fact that he says that all the documents were marked exhibit on the one day after the closure of the
That
evidence?
order sheet is available. That order sheet is available.
that
Yesterday
that
I'll give the order sheet.
The learned counsel has submitted that upon perusal of the order dated 12/9/2011, it would reveal that all the documents of the plaintiff,
Both parties.
of both the parties,
Yes.
were marked on the same day.
Same day. नॉर्मली होता है हम जब कोई डॉक्यूमेंट टेंडर करते हैं प्रूफ करते हैं दैट इज मार्क्ड एज एविडेंस और वी फाइल अ पिटीशन दैट दिस इज अ पब्लिक डॉक्यूमेंट इट मीन मार्क्ड इट इज मार्क्ड एज एन एविडेंस।
Additional evidence करके तो petition फाइल होगा ना, even if it is to be marked in whatever manner. ऐसे आके कोर्ट में एकदम फाइल कर देंगे और मार्क हो जाएगा, ऐसा होता है क्या?
जो रेंट रिसीट भी
नहीं, this is something very serious. जो हम लोग इतना कहानी सुन रहे हैं यहाँ पर और एक एक डॉक्यूमेंट हम लोग देख रहे हैं, तो parties are not confronted with the documents. कैसे इस तरह से एविडेंस होता है? How is it permissible?
that I'll verify.
आप प्लीज आप वेरीफाई करिए, इनको ऑर्डर शीट दीजिए, इनको ऑर्डर शीट
You
दीजिए।
have taken out the order sheet also, which is at page number.
डेट बताइए 12/9/2011।
12/9/2011.
ये अमेंडमेंट फाइल हुआ है, there was an amendment order 6/17
By the defendant.
वादी की ओर से, नो ऑब्जेक्शन, अमेंडमेंट अलाउड।
Defendant का भी
डिपेंडेंट का भी है, CWJC में ऑर्डर हुआ था, उस ऑर्डर के तहत ये सब हुआ है। क्या कोई ऐसा था कि यहाँ पर शुड बी टेकन इनटू एविडेंस?
क्या चीज़?
CWJC नंबर 3772 3772 of 2008. Order निकालिए इसका. WPC number 3772 of 2008. 3772 of 2008. ये तो 5 to 10 की तरफ से हुआ है.
नहीं एग्जिबिट्स हम लोग का तो एबीसीडी सीरीज में जो वो हम लोग की तरफ से हुआ. 1 2 3 4 का सीरीज में जो वो प्लेंटिफ की तरफ से हुआ है. ये मर्जी में कंडीशन एग्जिबिट 9A और 4M फॉर ये और तथा M फॉर जिके 10 10A 10B 10C अंकित किया गया. उससे पहले ब्रदर्स 9 हैज बीन एग्जिबिटेड ऑन दैट डे ओनली.
GB है उसमें.
Exhibit list shows that all those documents were marked without objection. If documents were marked without objection, then all this question.
फिर देखिएगा आपको तो बहुत बहस करना पड़ेगा.
हम बात करेंगे.
ठीक है. मतलब ध्यान रखिएगा ये सारी
हम
चीजें.
ठीक है. I'll go to each and every question. I'll not get an incorrect or wrong order from your lordship. I'll go to each and every question which has been raised.
ठीक है, सुन लिए. अब बताइए.
एक चीज गलत तुम लोग तो मेरा गलती से हम लोग बोले थे कि हम लोग इनफॉर्म नहीं फाइल किए. हम लोग का एम रोल है लॉर्डशिप एग्जिबिट H.
ऊपर लिखा है क्या? Enroll इनका. They are not filed in form. He says that the corresponding N form filed by the dependent number 5 to 10 has been marked as Exhibit
H.
H. और बताइए. सारा कहानी इसीलिए. ये सब प्रॉपर्ली एग्जिबिट होता ना तो यू वुड हैव कॉन्फ्रंटेड ईच अदर. ये डिटेल नहीं है, वो नहीं है.
ठीक है. Let us assume whatever.
Just
I'll
let
answer
him
to,
finish.
yes.
Just hold on.
I'll answer because the exhibit list shows all
Without
these documents
objection.
are without objection. So how at this stage
That's
this particular question?
हाँ बताइए. और क्या आपको बहस करनी है?
Lordship, the issues were framed in the judgment. One of the issues, specific issue was whether this suit is bad for non-gender or misgender of necessary parties.
तो आप बहस कर लीजिए. That has been argued.
Yes, no, I just wanted to read the judgment of Lordship वहाँ पे जहाँ पे ये issue decide किया.
क्या बोलते हैं डिसाइड किया बताइए. हम लोग पढ़ चुके हैं जजमेंट.
If not, my learned friend has
फुल टेक्स्ट ही हम लोग पढ़े हैं. अब
जी.
बताइए आप क्या बोलना चाहते हैं उसमें.
No, there is no proper discussion and nothing has been stated. Lordship, when the suit is for Lordship, that is in paragraph 16 of the judgment. Lordship, the suit is for declaration of possession and Your Lordship, declaration of title and confirmation of possession. Now, Lordship, we have in our written statement given the details of Lordship as many as 64% in whose favor deeds have been executed right from the year 1962-64 all throughout. Lordship, none of them were made parties. One. Second of these, the state was a necessary party. Whose M form is correct, whose M form is not correct, who is in possession, how much land has vested with the state government. Lordship, the code below says that as I'm just reading out, उपरुक्त with respect to this issue only, उपरुक्त वाद बिंदु 3 और 4 पर आए हुए उपरुक्त मौखिक और दस्तावेजी सबूतों को देखने के बाद न्यायालय पाते है कि वाद बिंदु संख्या 3 पे जहां तक प्रश्न है, इस वाद में अनेकों लोगों का सिविल प्रक्रिया संहिता के आदेश नियम 1-10 के अंतर्गत आवेदन देकर पक्षकर बनाने की प्रार्थना, जिसे अदालत ने अपने निर्देश संख्या 5/9/2009 में उल्लेखित किया है कि जब इन विक्रेताओं का ही अधिकार सक्षम न्यायालय के द्वारा नहीं किया गया, तब विक्रेताओं को जिन खरीदारों को का खरीदा है उनका भी स्वायत्त हित अधिकार एवं कब्जा प्राप्त नहीं हो सकता तथा इस आवेदन को खारिज कर दिया. ऐसी स्थिति में इस बार को आय संयोजन और कुछ संयोजन के आधार पर प्रभावित नहीं माना जा सकता है. Lordship will take into consideration the suit was brought Lordship in the year 2006. If some person whom we say that we have transferred through registered it in the year 1964, suppose Lordship the court comes to the finding is upheld that we had no title, we sold, they are in possession, they are, then the suit will be barred by limitation. Only one party, that is Sahara, with respect to them, they filed a suit saying that this is my cause of action. If cause of action was with respect to one particular small piece of land, not with respect to other land, the entire suit cannot be maintained by showing a cause of action with respect to one small piece of land. Secondly,
सहारा के नाम से तो कोई प्रॉपर्टी नहीं है,
सहारा का नाम से कोई प्रॉपर्टी नहीं
उसने
है।
डब्ल्यूएस में नहीं फाइल किया, दिल्ली अपील फाइल कर दिया है।
दिस कोऑपरेटिव सोसाइटी का नाम से,
कोऑपरेटिव सोसाइटी के नाम से सहारा कैसे दूसरा? हाउ?
No, we are contesting our party.
आप अपने पार्टी का बात करिए, सहारा का काम ही मत सुनाइए।
नहीं, हम बोले इनका जो cause of action है, with respect to Sahara only. हाँ.
With respect to Sahara we ran with respect to the suit property. As per their case.
Yes, their case is lordship, their right accrues lordship right prior to vesting. Now the suit has been brought in the year 2006. Cause of action has been shown that Sahara has issued an advertisement. If that is a cause of action, lordship, then they have to show the limitation with respect to lands which Sahara has never claimed and which has been made a part of the suit property. They were not bothered if somebody else was in possession.
It will not bind them.
Yes.
It will not bind them. इस पे क्या सोचना है? जिसको पार्टी नहीं बनाया उसको बाइंडिंग होगा नहीं होगा क्या होगा वो जानेगा।
नहीं, लर्नेड कोर्ट भी लोग बोलता है कि अगर मेरा टाइटल नहीं डिसाइड हुआ है तो उनका टाइटल तो ऑटोमेटिकली नहीं है।
उनका केस आप मत बहस
करिए।
जो परचेजर या पार्टी नहीं है उनका केस आप मत बहस करिए। कोऑपरेटिव सोसाइटी आप नहीं है, आप उनका केस मत बहस करिए।
Secondly, our cases beside those persons, state was also a necessary party. This honorable court also felt it necessary at one stage that state is a necessary party, therefore invited. So in such situations, suit should have been dismissed on ground of non-renewal of necessary.
तो स्टेट गया था ना, स्टेट ही तो गया था ना, कौन गया था?
State filed an application, please delete my name, and then it was deleted.
Ashrafi Hospital भी गया था. That
So
was
state is a necessary party. That was the cause of action to uphold.
वही तो ground ही था कि I was made party in appeal, therefore the judgment was wrongly passed against me with regard to 3 counts.
इसलिए आप state is a necessary party बोलने का कोई scope नहीं है।
This was my argument. No, even if state is not a state had gone to Supreme Court saying the 3 lands.
भाई स्टेट का कोई भी चीज प्रूव करने के लिए स्टेट के अथॉरिटीज को विटनेस पे बुलाया जाता है ना। उसके लिए स्टेट को अलग से पार्टी बनाने का क्या जरूरत है?
ठीक है, लॉर्डशिप दैट आर्गुमेंट में भी नोटेड।
हम आपकी तरफ से थोड़ी आर्ग्यू करेंगे। आई डू नॉट नो।
यस दैट।
लेकिन ये जो स्टेट इज अ नेसेसरी पार्टी इन स्पाइट ऑफ द ऑर्डर ऑफ द सुप्रीम कोर्ट यहाँ से डिलीट हो गया, उसको आप चैलेंज भी नहीं किए। अब स्टेट इज अ नेसेसरी
टेक बैक माय सबमिशन। आई से लॉर्डशिप दैट दोस documents which they have filed could have been proved, your lordship,
marked without objection.
Lordship, those were filed.
You'll see the consequence.
Yes.
Marked without objection. All the documents.
Yes, where the lordship will also see, your lordship, after filing, whether lordship we got any opportunity to object or not.
भाई आपका तो marked without objection है तो we do not know आपका opportunity मिला कि नहीं मिला।
That will be reflected in the suit proceedings itself.
हम बैठ के थोड़ी पढ़ेंगे, आपको बताना होगा।
हम लोग का तो
या आपके
basic
absence में मार्क हो गया डॉक्यूमेंट। In your absence it was
Lordship,
marked and it was
my
wrongly recorded that it was.
My specific case is, lordship, those documents which has been marked as exhibit is not a proof. The marking of exhibit is one part, and proof of document is one part.
That's
Lordship, if a document has been marked as exhibit and requires a formal proof, lordship, which has not been proved, lordship, then lordship, those documents. My lordship, they may argue that M form is a public document. M form cannot be a public document.
और नहीं देखेंगे।
These are.
The learned counsel for the appellant has submitted that merely because the documents have been marked without objection, the same does not amount to proof of the document. And M form particularly is not a public document, and therefore those documents were required to be duly proved through cogent evidence. And since the documents were exhibited at that end of the trial, there was no occasion to. Those documents were ultimately not proved. Your turn. और कोई बच्चा है? प्लेंटिफ को सबसे बाद में सुना। हो गया सर, कोऑपरेटिव सोसाइटी आप कौन हैं?
बट हम लोग तो प्लेंटिव के थ्रू ही क्लेम कर रहे
प्लेंटिव के थ्रू,
हैं।
चलिए ठीक है,
इसी के लिए
ठीक है,
चलिए।
ट्यूसडे ऑनवर्ड्स
प्लेंटिव नोट करेंगे, उसके बाद फिर जो
क्या हुआ?
योर लॉर्डशिप हम पहले ही बोल कर लिए, हम इसलिए बोल दिया
तो शुरू तो करिए, ट्यूसडे ऑनवर्ड करेंगे, आज नहीं करेंगे।
better. I'll say only 2 words. I'll start few lines only, and then your lordship may proceed.
Argument of the respondent number 10 to 15 representing defendant number 5 to 10 is correct. The argument of the respondent plaintiff has commenced.
First question would be as to who can be aggrieved and who can be the appellant. So here your lordship has taken note of the fact that there were 3 defendants who were originally, they had filed defendant number 3, 1 and 2 were Sahara and its officer.
Yes. Officers. Defendant number 3 was?
Yes. One is Sahara India Commercial and the second one is Regional Manager Sahara. So they both are Sahara. Third is Karm Yogi Nirman Sahara.
Cooperative.
So let us first see what is the right of appellant number 1 and 2. Sahara are appellant number 1 and 2. In written statement filed by defendant number 3, Sahara they did not file any written statement. In written statement filed by defendant number 3, they make a very specific statement in their para 3 of their written statement that Sahara does not have any interest whatsoever in the property.
Para number?
Yes, 3.
You see, you have disclosed the cause of action by saying that Sahara had advertised.
Yes, that was the, I could not have. So therefore I have disclosed that when the paper publication, this particular 100 acres of approximate land was published in a newspaper, then we came to know and that matched with our property and therefore that was the reason that we inquired and then we filed a suit. So based on that paper publication, we were required to file a suit.
Because,
that was the
because
reason.
you could make out that somebody is claiming the property.
Yes, yes,
So
somebody
therefore
and
you made, so Sahara did not file the written statement to even to justify that admission.
yes, yes. Yes, para 3. The present suit is bad for non-joinder and misjoinder of parties. As regards misjoinder of parties, it bears mentioning that defendant number 1 and 2 have no concern whatsoever with the suit property and as such their names may be liable to be deleted from the area of party. Very specific statement of the defendant number 3 itself, and now they have jointly filed an appeal. So 1 and 2 is absolutely no concern with this. Now as regards 3, now we were the original plaintiff, we filed a suit. Approximate total area of the suit properties, I'll come to the merits also, but I'm just pointing out the total area is approximately 85 acres. And then when the suit is decreed, let us, as of now, let us forego the reasonings, whatever was there, ultimate decree is there. So only a person who is aggrieved by the decree, judgment and decree, he can only prefer an appeal. So here, Karma Yogi, when they defended their suit, they only brought few of the sale deeds, only, which was out of 85 acres, only few of the sale deeds they produced. So therefore, they could have defended only to the extent of the sale deeds which they had produced, only to the property which the Hattas had transferred to them. only to that extent they could have defended the suit and they could have challenged the decree against them.
To that limited extent.
Only to that limited extent. How can they challenge the entire decree itself? So here they have to say that Dattas had rightly transferred me these properties by these sale deeds, and these sale deeds are form part of the entire suit property, and therefore these are the portions which may be taken
And
out.
Dattas have not filed any appeal.
Yes, that is the, as your lordship. So now Datta's entire dispute was between Pauls and Datta. So Dattas could have filed an appeal because that would be the consequence. Here Dattas they do not. They what they do, Dattas they only support the appellant. That means appellant number 3. They can only support appellant number 3 with regard to the property which they have transferred to Karmyogi. That's all. Absolutely confined. They could
Only
not
to
have-
the extent the
Only to-
cooperative society had proved its case.
Yes, exactly.
And therefore, whatever sale deed was executed and exhibited,
Yes.
right, at best, it can be non-joinder only to that extent.
Only to that extent. So what would be the non-joinder also? That also I'll come. Now let us assume, Your Lordship, I'll try and demonstrate from this case itself. Now, as far back as 1941
Please
itself.
hold on. The learned counsel for the respondent plaintiff has submitted that defendant number 1 and 2 were Sahara and its officers, and defendant number 3 was the cooperative society. So far as defendant number 1 and 2, who are the appellant number 1 and 2 in the present case, they did not file any written statement. However, a written statement was filed by defendant number 3, and in paragraph 3 of the written statement, a specific stand was taken by defendant number 3 that Sahara does not have any interest in the property, and accordingly, either as per defendant number 3 and defendant number 1 and 2, having not filed any written statement, there is no occasion for defendant number 1 and 2 to file the present appeal. The learned counsel has submitted that the cause of action arose to file the suit only when defendant number 1 and 2 had advertised for the purposes of sale of the property involved in the present case, but the defendant number 1 and 2, having not filed a written statement, did not justify the issuance of such advertisement. It has been exhibited?
The sale deeds.
No, advertisement.
Advertisement, yes.
The advertisement has been exhibited before the learned court by the exhibit number dash.
Yes.
The learned counsel has further submitted that total area of the suit property is 85 acres. The suit was decreed, and the defendant number 3 had only produced few sale deeds to assert that they had the right to sell property to third parties, and the property was sold. The learned counsel submits that the relief to defendant number 3 could at best be confined to the sale deeds which were produced by defendant number 3 and no more. Sale deeds cannot be produced by way of sample. If the entire property of 85 acres was claimed by defendant number 3, then each and every sale deed was required to be produced and exhibited. कितना एरिया का प्रोड्यूस किया है sale deed?
वो अपना गवाही में ही बोले हैं. वो exact जगह I'll place it before Your Lordship. Only one more thing, Your Lordship.
He has also submitted that the fight is primarily between the plaintiff and the Dattas, who were defendant number
No, 5 to 10.
5 to 10, and Dattas are trying to agitate their case before this court on the strength of the appeal filed by defendant number by the defendant number 1, 2 and 3. He submits that defendant number 1 and 2 as submitted above has no locus, and so far as defendant number 3 is concerned, their right, if any, is confined only to the extent of sale deed executed by them in favor of third parties and exhibited before the court. And Dattas, having not filed any appeal, they have accepted the judgment and
Yes, absolutely. And
it is binding on them.
yes,
At
absolutely.
the instance of defendant number 1, 2 and 3 who are the appellants before this court, the decree passed against Datta cannot be satisfied.
Yes. And they could have only defended to that extent. That was one. Now, Your Lordship, with regard to the first point which I had said that Sahara India does not have any interest, their own witness, who was Manish Kumar Singh, examined as on behalf of defendant first said, he himself says that मैं इस वाद में प्रतिवादी संख्या 3 का सचिव हूँ. Very important. Now he says Manish
This is
Kumar Singh.
DW?
DW.
1, I think.
हाँ,
Secretary.
साक्ष्य संख्या 1. The defendant first said.
Secretary of defendant number 3.
The secretary of defendant number 3, and he says in para 25, मैं सहारा इंडिया के ऑफिसर पद पर नौकरी करता हूँ. And then 26 सहारा इंडिया प्रतिवादी संख्या सो एंड सो 1996 से मैं नौकरी कर रहा हूँ. And then 28 and 29 as the most important paragraph, विवादित जमीन से सहारा इंडिया को कोई सरोकार नहीं.
The learned counsel has in particular referred to the evidence of defendant number 1, evidence of DW1, who was the secretary of defendant number 3, and has submitted that this defendant has disclosed his identity as an employee of Sahara India and has asserted that he has been working in Sahara India since 1996. And this witness, being an employee of Sahara India and deposed on behalf of defendant number 3, has stated in paragraph 28 and 29 of his evidence that Sahara India has no concern with the suit property. The learned counsel submits that the appeal filed by defendant number 1 and 2 is not maintainable.
Rest, Your Lordship, can I?
Is
Because
there,
I have
no,
not
no,
made any
is there
rule.
any relief granted against defendant number 1 and 2?
Okay. I'm sorry. Since after the plaintiff is
The
अभी
suit
वही
has been.
उनको डॉक पे रहने दीजिए, नहीं तो सवाल आपसे पूछेंगे ना तो आपका दिमाग दुरुस्त हो जाएगा.
I'm sorry.
बताइए.
Suit has been decreed in.
Is there any relief granted against? You see, Sahara is not in possession of property.
No,
They are not the seller of the property. Is there any relief granted against the defendant number 1 and 2?
no, not directly. It has been
Even
only
indirectly?
said that the plain my title has been declared.
Okay.
That is. So
And
no,
defendant number 1 and 2 are not seeking their title.
no,
The learned counsel has further submitted that no relief as such has been granted against defendant number 1 and 2, inasmuch as the defendant number 1 and 2 never claimed title over the property, and what has been declared is the title of the plaintiff, and the dispute between the plaintiff and the defendant number 5 to 10 has actually been decided.
yes, and 3 also. 3 because.
And defendant number 3, to the extent
Yes.
it was to the extent they claimed the property through the
5 to 10.
they claimed the property by way of sale deed exhibited by them. So sale deed of defendant number 3 to third party has been exhibited, or sale deed of Dattas to defendant number 3 has been exhibited.
Because some properties were transferred by Dattas to third party, and from third party to them they claim.
Okay.
This was, but that clarity, Your Lordship, I don't want to make any.
You do that, right? You prepare a list of sale deeds which has been produced. दो तरह का sale deed होगा. There could be sale deed executed by Dattas in favor of the defendant number 3. Second category would be executed by Dattas in favor of third party, and those third party executed in favor of defendant number 3. And the third category would be sale deed executed by defendant number 3 in favor of fourth parties. ठीक है, 3 कैटेगरी समझ आ गया? बताइए.
Datta executed to third party, and then third party have executed any to another, and then after lordship, the third one is that from whom the defendant number 1 has purged.
Let me repeat it. हिंदी में. दत्ता ने बेचा कोऑपरेटिव सोसाइटी को, फर्स्ट कैटेगरी. दत्ता ने बेचा थर्ड पार्टी को, एंड थर्ड पार्टी सोल्ड इट टू कोऑपरेटिव सोसाइटी. एंड थर्ड कैटेगरी इज कोऑपरेटिव सोसाइटी ने किसको बेचा. ठीक है, इसका चार्ट चाहिए, डेट ऑफ एग्जीक्यूशन ऑफ सेल डीड चाहिए, कौन वेंडर है, क्या है, कितना एरिया है चाहिए हम, और एग्जिबिट नंबर के साथ. आपको वीकेंड का होमवर्क दे दिए हैं, बढ़िया से कर लीजिएगा.
वो तो वो हम लोग ऐसे भी नोट कर लेते हैं YouTube देखकर.
एक केस में ऐसे ही हुआ, हम सोचे कि कोर्ट में हम आर्गुमेंट कंक्लूड कर दिया. हम सोचे छोटा सा मैटर है, यूट्यूब देखेंगे तो हमको तो सारा रिकलेक्ट हो जाएगा, सब रिकॉर्डेड ही है. उसके बाद वो उस जो रेलेवेंट पोर्शन था ना, वो पोर्शन का मतलब गड़बड़ था, ठीक से प्रॉपर रिकॉर्डेड नहीं था, या को ठीक से समझ में नहीं आया या कुछ. देन आई हैड टू पोस्ट इट फॉर हियर.
वो करना भी चाहिए, करना भी चाहिए. वैसे ही one day I was taking note of that 1 hour probably of your lordship's first video was not there.
कभी कभी ऐसा हो जाता है, ऐसा भी ट्राई की सारा रहे. हम लोग भी रेफर करते हैं, हमारे स्टेनोग्राफर्स भी रेफर करते हैं.
Easy तो होता है. Easy.
चलिए.
Can I continue on next day?
हाँ, yes.
Without note I don't know.
आप लोग नोट वोट बनाइए. आप लोग सुन रहे हैं ना इनका बहस, अपना भी नोट बनाइए. नोट में ये सारा चीज इंक्लूड करिए. एग्जिबिटेड नहीं. अच्छा, उन्होंने बोला है.
मैं गलत चीज
नहीं
अच्छा नहीं. हाँ,
लेकिन ओरल एविडेंस है.
वो है, प्लेट में लिखे हैं और ये में
और 1 and 2 ने इसको डिस्प्यूट नहीं किया.
नहीं dispute किया. But I'll respond to all these query wise here.
ये एग्जिबिट नहीं दिखेगी इसमें. At the request of the learned counsel for the plaintiff respondent holds this case for further hearing on Tuesday.
At 2:50.
आप लोग से एक रिक्वेस्ट है, जितने भी ऑर्डर्स हम यहाँ लिखाए हैं सारे अपलोड हो रहे हैं. आप एक साथ कर लीजिए आप लोग, और उसके बाद आप लोग अपना, ठीक है, ध्यान देंगे. सारा जो भी है कर दें, बाय एंड लार्ज सब अपलोड हो गए, डे टू डे अपलोड हो गए, कल वाले भी आज हो गए. आज सुबह तो एक ही केस पूरा समय निकल गया. हाँ? नहीं, जब तक हम ग्राउंड तक नहीं पहुंच जाते हमको सेटिस्फैक्शन नहीं होता. एक झोपड़ी जो है ना, महल से ज्यादा इम्पोर्टेंट है, और यहाँ पे झोपड़ी का ही डिस्प्यूट ज्यादा है. एक हम पार्टीशन सूट देख रहे थे, 3 रूम के पीछे 10 भाई का क्लेम. 3 रूम के पीछे 10 भाई का क्लेम. लेकिन वो रूम उसके लिए बहुत कभी कभी किसी किसी केस में ना सूट प्रॉपर्टी का फोटो दिख जाता है, वो आज वो आईए वगैरह फाइल होता है स्टे के लिए, एग्जीक्यूशन के लिए, स्टे के लिए, तो लगता है कि वेरी सेंसिटिव। चल
From submitting is for hearing under order 41/11, item 16, second appeal 44 of 2019.
Who is there? अपील नहीं सकता, घर चलेगा। Who is appealing? अच्छा टाइम आ गया। Nobody appears on behalf of the appellant. Eviction suit है। Respondent appeal। Appellant absent। Post on Wednesday in supplementary August.
Item 17, second appeal 238 of 2023.
Yes.
Defendant's appeal. His suit for eviction was instituted by the plaintiff on the ground of default, subletting, and was damage to the property of the suit premises. The case of the plaintiff is that defendant was inducted as tenant and the last paid rent was rupees 250 per month, which was paid till September 2010, and he started defaulting payment of rent from October 2010.
Just a moment. The period of default mentioned is just a moment.
From October 2010.
October 2010 to till the
Yes,
date of
continue.
filing.
Yes, date of filing.
There were 3 grounds for eviction.
Yes, another is subletting
Subletting.
without consent of the plaintiff.
Or damage to the suit
Prior
property.
damage.
All the 3 are distinct grounds. Your case in all the 3. They're absolutely listing down, and by themselves it is sufficient for
The court
eviction.
below has only dealt with the default part. Only the default part and
Subletting and damage, there is no finding.
no finding and my defense was struck. So virtually there and no, but what we have to see is whether the plaintiff could make out because there was specific denial of relationship of landlord and tenant. The case of the defendant is that his landlord was the property belongs to Jaiswal family and his landlord was Bakilal Jaiswal to whom he had paid rent and further that when his landlord was going for treatment he had given amount of 6,000 to this Bakilal Jaiswal and he had promised that he will adjust it from the rent.
Yes.
I am praying for not to be.
Who are you?
I am junior to Sankar.
But this is no substantiation of law has been framed so far. अभी जरूरत नहीं है उनका, उनको बता दीजिए उनकी कोई जरूरत नहीं। हाँ बताइए। Yes.
Yes. So you should be find from para 9 and this place.
Let us see the case of the plaintiff.
Yes. Can I place it from the judgment?
Yes, you please.
The present suit has been filed by the plaintiff for eviction of defendant from Schedule A property and for realization of arrears of rent, the sum of which is 3250 described in Schedule B of the plaintiff. Briefly stating, the case of the plaintiff as complaint is that the plaintiff is landlord in respect of a house and premises situated in New Ward number 5, UNPS Chakrabarti, bearing municipal holding number 99, situated in the number 87, Ward 148, quarter number 4, having two proposed shop district West Sembhum within jurisdiction of this court mentioned in Schedule A, which is herein referred to as tenanted premises. The defendant has been in occupation of the tenanted premises as a tenant and under the plaintiff. It is further case of the plaintiff that the tenanted premises is part and parcel of properties known as Jaiswal properties, and the plaintiff has been realizing rent from defendant, and rent received used to be granted to him whenever rent was paid by him. It is further case of the plaintiff that the last paid rent to the defendant by the defendant to the plaintiff in respect of tenanted premises is rupees 250 only per month, and the tenancy to the defendant in respect of tenanted premises is a monthly tenancy, which runs month to month according to English calendar. The rent for each month becomes due on the last day of each month and is payable by defendant by the last day of subsequent month for which rent becomes due. It is further case of the plaintiff that defendant last paid rent for the month of September 2010 on 7/10/2010 and thereafter failed to pay rent in spite of repeated requests made by the plaintiff. And
You see, when there is no denial of landlord-tenant relationship on
There is
your
denial.
part, from where do you say?
yes, I think that is case of the defendant.
Case of the defendant, the defense was struck off.
Defense was struck off. Now, what we have to see is whether the plaintiff himself could prove the relationship of landlord and tenant.
So the plaintiff, the witnesses of the plaintiff was cross-examined.
Yes, process. Just briefly, I just want to place the defense, just to understand the background. It starts from paragraph 4, where the suit as filed by the plaintiff is not been interval, both in law and also in fact. The suit as framed is bad in law. Now, your leadership from the fourth line that there is no relationship of landlord and tenant between the parties. The suit and instructs view of the matter. Suit under section 11(1)(d) of the DRC Act is entirely misconceived in eye of law. The real motive of the plaintiff is to obtain degree for right title in garb of eviction built by circumventing the law and by avoiding payment of court fee at ad valorem scale on the present market value of the property. The mode and valuation of the suit and claim for areas of rent both are baseless, illegal. Plaintiff has no right to come out the demand or claim for the rent. The suit is undervalued and is illegal. The present market, Your Worship, the relevant where I have been is here. That it is in the next page, about 5-6 lines from the top. The plaintiff is not entitled to any relief whatsoever that the suit is bad for non-joinder of the proprietor from namely Jaiswal property, that's the non-joinder of Bakilal Jaiswal. The defendant is advanced distinctly that the suit is bad for non-joinder of Bakilal besides others. Non-joinder of Bakilal has died leaving behind his surviving heirs. Representative in his place, the legal representative of Bakilal are both necessary and proper party to the suit. The defendant is not the person holding the suit property as described in Schedule A. The person in use occupation of the premises is in question is Dr. S.P. Lal. Dr. S.P. Lal is still alive and is in possession of the premises of the suit. The suit is therefore bad for having filed against the wrong person. Plaintiff cannot proceed with the suit in absence of S.P. Lal. The description given in Schedule A of the complaint is denied, is incorrect. Defendant is not in occupation of holding 99. Defendant holding number 99 is a big one. Plaintiff has not stated as to whose name the land under Khata 87 plot number 148 of Round Chakra Road stands recorded in Hal survey. As far as the defendant knows, the house and premises under Khata 87 is property of Bakilal Jaiswal, son of Kashinal Jaiswal. Bakilal Jaiswal has been executing a registering deed of sale of transferring the property under Khata 87. Even in 2011, Bakilal has executed a registered deed of sale in respect of the property under Khata 87. Bakilal is claiming the property on behalf of Umar Lal. That there are only one room and one veranda and not two rooms as stated. Plaintiff cannot maintain the suit unless recorded credits as per Khata 87 made parties. It is not stipulated by
You
the
see, you say that somebody else is in occupation.
somebody else is in occupation and
How are you agreed by the eviction?
somebody else is in occupation, and secondly, I say that the landlord, actual landlord was Bakilal.
You don't need to worry because you are not
Yes.
in possession of the property as per your written statement.
Ladyship will find at para 19, page, internal page 25, that my defense was struck off. Once my defense is struck off, all I request to see is whether the plaintiff could prove the relation.
Need not. You see, your specific case is that you are not in possession of the property, the actual tenant is somebody else. Whenever there is a execution, that person will object. You claim that you are not in possession of the property.
That is then the written suit, and then again, I have also
That's
stated
it.
in WS that this Bakilal Jaiswal
Nothing,
issue.
on the face of your stand that you are not in possession of the suit property. Nothing, you are not agreed.
I understand, but then again, there are pleadings that effect that I had paid rent to this Bakilal Jaiswal on behalf of Mr. Dr. Lal.
But you are not in possession of the property.
That is what I say.
That's it.
And the Landlord Code deals with default. It is issue number 3.
The fact that you are claiming that the property belongs to Bakilal Jaiswal, there is no evidence to that effect.
Yes, but the plaintiff.
The sale deed is not exhibited because your defense was struck off.
The plaintiff also requires to prove this case, even if there is no
Plaintiff
defense.
will not bring the sale deed.
Plaintiff requires to prove this case so that at least prima facie he has to make out that
Plaintiff has to prove his case that he was collecting the rent.
he was the landlord and
Not necessarily. He was collecting the
collecting
rent
rent.
that is sufficient.
Collecting rent, yes.
So he has
collecting
proved
rent.
it.
And therefore, I wanted to place the cross-examination. Cross-examination of this PW. He is the plaintiff. It starts from page 15, internal page 15.
Let us see first the findings of it.
Yes.
What is exhibit 1 and 1 by 1?
One and one way, one are rent receipts. Counterfoil of 2, sorry, there is a counterfoil of 2 receipts.
Yes. That is sufficient. Mr. Rai, you don't have this.
I have a very weak
Let's
case.
take it.
That too, it's a concurrent finding. But then, just for my satisfaction, I can take the leadership to page 15, internal page 15 on the trial court judgment, where the cross examination is dead.
Yes.
During cross examination, is stated that his natural father is Bakilal Jaiswal. Ishan Lal Jaiswal prepared deed of adoption in the year 51 in his favor. At that time, he was about half to 2 years of age. He cannot tell the month and date of paper related to deed of adoption. He has no knowledge as to whether he has submitted it to the court or not. Kishan Lal was the younger brother of Baki Lal, but his fact is not mentioned in the claim or affidavit. He does not have knowledge as to whether SP Lal runs his homeopathic shop in the suit shop. He does not know Dr. SP Lal. He knew that Dr. SP Lal is on rented house at ₹16 since 1970, and now the rent is ₹250 per month. Rent receipts bearing number 236697 contains his name as L.K. Jaswal, and the same does not possess his signature for identification. The same are marked as Exhibit X, XY1 and 2. House number of the suit property is 4. Receipts numbers 68413451771 771 888 are marked as Exhibit A, AY1, A by2, 3, 4 and 5, upon which signatures of DK Lal is there, which he identifies. Receipt number 684771, 888, 84, 178, 68 are in name of SP Lal, and receipt number 30451 are in name of Dr. Ashok.
Ashok is the
Defendant.
defendant.
It is not true that SP Lal at present sits in the shop and runs the said shop. He does not identify Dr. SP Lal. He does not know Dr. SP Lal is the father of Dr. Ashok Kumar. He is collecting rent from the defendant from March-April 2010, and prior to that, BK Lal used to collect rent. Counterfoil of rent receipts given by BK Lal are prior to March 2010. Suit property is named is in his name, whose registered deed is within the said gift was given to him by Narmada Devi Jaiswal in 1951. It is true that the rent receipts under the capacity of house are not in name of his father BK Lal, and the said receipts name has been shown as Jaiswal property, and it has 3 shares, namely Raj Kumari Devi Jaiswal, Usha Devi Jaiswal and Dalit Kumar Jaiswal. He has filed rent receipts in the court upon which Jaiswal properties has been written, and in no receipt his name has been mentioned, but his signature contains on receipt which he identifies as Exhibit 1 and XY1. There are 3 shareholders of Jaiswal properties. They are Raj Kumari Devi Jaiswal, Dalit Kumar Jaiswal and Dalit Kumar Jaiswal, out of which Kumar Devi died in 2004, whose heir is her husband BK Jaiswal, and both have 6 daughters and 1 son. In his print, it is not written Jaiswal property has 3 shares, and partition among them has been made, whose paper has not been filed in court. It is not written in the plain that shareholder has been allotted this property. It denies the fact that Dr. SP Lal is at present possession of and is tenant as per voter list, name of his wife Chandramani Devi and his second wife
How
Nandini.
DW1 has been examined?
His period.
DW1.
DW1 was examined. Later on, his defense was stuck up.
So even this defense would go.
So therefore, what I wanted to place is that he could not himself prove the relationship of landlord and tenant to the parties. The plaintiff.
But
Para
where is the
19,
finding?
your lordship.
Where is the finding? But 2 rent receipts has been exhibited, which has been believed by both the courts. So in second appeal, how do you frame a substantial?
There are 2 counterfoils, but he also admits that prior to him, it was his father, natural father. Now he is adopted. He was adopted by his uncle. So whatever he cannot succeed to the once the adoption is complete, he cannot succeed to the property of his natural.
We are not deciding.
We are not going to that, but then again, what I wanted to show your ladyship that this plaintiff also could not prove that he is the landlord. Ladyship will find in para 19 that my defense was struck off. Para 19 it is pertinent to mention here that this court wide order dated 3/1/2020 directive given deposit the areas of rent and due to non-compliance of the posted order, this court wide order dated 11/2020 struck off the defense. So once my defense is struck off, my evidence also cannot be considered, but by the learned courts below have taken into consideration the defendant's
They have recorded it, but they have not considered.
No, the finding.
The finding is in para number 20.
Yes, sir.
Finding is
Page,
only in
page
para
23, yes, page 23.
25.
It
They are
starts-
discussing it. They are discussing it.
It starts from internal page 22.
No, maybe there. You see the finding after recording that difference has been struck off. How do you overcome para number 20?
Leadership, this relationship of landlord and tenant is dealt at page 22, internal page 22. Now, leadership, kindly come to page 20, the next page 23, and last 5 lines from the bottom. The defendant in para 35 of his deposition has deposed that exhibit A series rent receipts bears his name and also admitted exhibit A by 11 bears signature of Lalit Jaiswal, the plaintiff. Thus, this court finds that there exists relationship of tenant and landlord between the plaintiff and the defendant. Hence, this issue is decided in favor of the plaintiff and against the defendant. And even on top of that, the leadership find these facts are clear in certain rent receipts were marked as A series, exhibit A to A by 12 on admission with objection, in which tenant name was mentioned as Dr. S.P. Lal and name of landlord was mentioned in particular exhibits again. So it has basically to record a finding whether there exists relationship of landlord and tenant. The defendant's evidence have been taken into consideration.
What about appellate?
Appellate court also does. It starts from findings, internal page 10, para 12.
By considering the point of non-joiner of necessary party, again this aspect of the matter as to whether Bakilal Jaiswal is a necessary party or not, that plea has been rejected. By saying that there is an admission in as much as with respect to exhibit 1 and 1 by 1. We will read the judgment as a whole, not in compartments.
So far as first and foremost, the plaintiff has to prove that there exists relationship of landlord and tenant. He has to do so by his own evidence.
That's all.
Once my defense is top up, my WS goes,
That's
my evidence goes. The appellate court ladies will find also takes note of my admission in written statement and in deposition. Can I please appellate court? That starts from internal page 11. In this regard, plaintiff names Lalit Kumar Jaiswal in para 1, 2, 3, 4, 5 of his deposition. He has filed the instance suit against defendant Dr. Ashok Kumar to get possession of the suit premises after evicting him here. He has given details of the suit within Shule of the claim in which defendant is in possession as a tenant on one basis. The suit property is part of that suit property. After receiving payment from defendant, he used to issue receipt. Further, he has issued receipt number 204 dated 5/7/2010, 201 dated 25/6/2010. After receiving that under his signature, he identified the counterparts of both the receipts which have been marked as exhibit 1 and 1. Further, defendant has denied in the written statement that he is tenant of the plaintiff with respect to the school premises, and the defendant, namely Jaswal, Lalit Kumar Jaswal, this is error actually. Dr. Ashok was examined as DW1. Now,
You see, whenever a defense is struck off, if it is struck off in the midst of a proceeding, then all the evidence of the defendant has to be deleted.
yes,
No.
it cannot be.
No.
It cannot be.
No, suppose he becomes.
If I can't-
Suppose there is an order for the payment of rent, and after 5 years he stops making payment rent. So therefore, till whatever evidence was led for the period of 5 years, and the evidence is led before the court, will be struck off.
It will be struck off. As if he has no defense. As
No.
if if he has no defense.
So whatever has been led, that will be led. Let us see the evidence here. This is under section 15.
Earlier it used to be 15, now it is 27. If in a suit for recovery of possession of any building, the tenant contests the suit as
Just
regards.
one, section 27.
We same parameter, yeah, same. In fact, I used the same wordings, but since this was under the 2001 Act, the proceeding was under 2001 Act.
Okay. So,
So section 15.
section 15. 2000, right?
Yes.
This is section 15 is right and liabilities of lessee.
No. Ladyship is referring to 2011.
This is deposit of rent determined by the collector during
No,
tenancy.
deposit of rent by tenants in suit for rejectment.
जरा बताइए तो कहाँ पर है? तो बोलिए बता। Can you read it?
Yes. The suit for recovery of possession of any building, the tenant contests the suit as regards claims for rejectment. Landlord may move an application at any stage of the suit. Suit for order from the tenant to deposit rent month by month at rate which it was last paid, and also subject to law of limitation. The arrears of rent, if any, and the court, after giving opportunity to the parties to be heard, may make an order for deposit of rent month to month at such rate as may be determined, and the arrears of rent both before or after institution of suit, if any, and on failure of the tenant to deposit the arrears of rent within 15 days of the date of the order, or the rent at such rate for any month. By the 15th day next following month, the court shall order the defense against ejectment to be struck off, and the tenant will be to be placed in the same position as if he has not defended the claim to ejectment. And further, the court shall allow the tenant to shall not allow the tenant to cross-examine the landlord's witness. If any proceeding referred to subsection 1, there is any dispute as to the person or persons to whom rent is payable by the court may direct tenant to deposit the amount payable by him under subsection 1, and in such case no person shall be entitled to withdraw the amount in deposit until the court decides the dispute and makes an order for payment of the same. If the court
the court may also refuse to allow you to cross-examine the witnesses of the landlord. If the defense is to be struck off, then cross-examination will also be. अरे ये सब में जजमेंट होगा, वे क्यों नहीं बता रहे आप?
नहीं, जजमेंट है कि हम क्रॉस एग्जामिन कर सकते हैं।
हम नहीं जानते, हम तो सेक्शन पढ़ रहे हैं।
This was under
आप हमको ये नहीं बताएं, नहीं तो हम मिस्टर मंजू प्रसाद से आइए सर, ये लोग हमको सही नहीं बताएंगे, ये तो लिटिगेंट है ना, तो नहीं बताएंगे।
जस्टिस इनमाई को
वो तो प्रोसीडिंग अगर केवल 48 का होगा, अगर 11(1)(c) का होगा, और जहाँ पर लिमिटेड आपको एग्रीमेंट है, उस केस में 48 का लाइन लगेगा।
नहीं सर, मान लीजिए कोई सूट चल रहा है, डिफेंस विटनेस भी चल रहा है, और उसके बाद जो है एक ऑर्डर होता है टू स्ट्राइक ऑफ द डिफेंस,
डिफेंस स्ट्रक ऑफ,
डिफेंस स्ट्रक ऑफ, तो पुराना जितना भी एविडेंस आया है,
नहीं वो स्ट्रक ऑफ
वो
नहीं
कैसे
होगा।
स्ट्रक ऑफ होगा?
It will be a struck off with respect to quat tenancy.
नहीं, क्वाट टेनेंसी भी जितना एविडेंस डिफेंस का आया होगा वो सब खत्म
नहीं
नहीं ना, मतलब उसका डिफेंस स्ट्रक ऑफ कौन से स्टेट से होगा?
डिफेंस स्ट्रक ऑफ जब भी होगा तो उनका जो रेज किया हुआ है ऑब्जेक्शन विद रिस्पेक्ट टू टाइटिल ऑफ द पार्टी, वो स्ट्रक ऑफ होगा, टेनेंसी से नहीं होगा।
टेनेंसी से
नहीं, जैसे रेंट डिफॉल्ट इन पेमेंट ऑफ रेंट, वो नहीं होगा, नहीं, हमारे विचार से नहीं होगा। और इस तरह का जजमेंट बहुत पहले देखे थे, अगर कहा जाएगा तो दे देंगे उनको जजमेंट।
Can I just pay your leadership? Kindly post it tomorrow. Because there is a judgment I remember of Justice M.I. It says that I can cross-examine the witness. Defense, the tenant can cross-examine the witness.
यही वर्ड है उसमें, with respect to quat tenancy.
with respect to 14.
हाँ, रिपोर्टेड। एक मिनट पार्ट चला के
अब मिस्टर रॉय को सीधा केस लेकर तो खड़ा नहीं होगा।
नहीं, ये माइट बी नॉट
आपको
रेडी।
तो सब पता है, आप उनको बता नहीं।
नहीं,
हम मेरे
ऐसा हम लोग नहीं करते। अभी पुराना कोई नया लड़का नहीं है मैडम।
So far as I recollect,
तो ये तो बहुत कॉमन चीज है ना, कि अगर मान लीजिए 5 साल 10 साल सूट चल रहा है, उसके बाद पेमेंट ऑर्डर हुआ बाद में, तो इस बीच बहुत एविडेंस प्रोसीड कर गया कोर्ट, तो आखिर जो एविडेंस ऑलरेडी रिकॉर्ड पर है, या मान लीजिए कोई बीच में डिफॉल्टर हो गया, 10 साल तक पेमेंट किया, उसके बाद डिफॉल्टर हो गया, तो 10 साल तक जो वो पेमेंट किया, उसमें जो एविडेंस दिया वो सब खत्म।
नहीं, ऐसा नहीं, तो देखना पड़ेगा। सर्टेन रेस्पेक्ट में वो डिफेंस खत्म होगा, सर्टेन रेस्पेक्ट में नहीं।
डिफेंस अगेंस्ट इजेक्टमेंट खत्म हो गया।
हाँ,
I cannot replace reliance on my written statement. Readings भी I cannot rely, and I cannot rely upon my evidence also. All I can do is cross-examine the.
एक जमाने में इस तरह के ऑर्डर का बाढ़ आया हुआ था, एक लाइन से बहुत सा ऑर्डर हुआ था डिस्ट्रिक्ट कोर्ट का, जिसमें जजमेंट आया है अपने राज्य में।
किनका
तो
जजमेंट?
बहुत तो इकबाल साहब का भी था, और भी जजेस साहब लोग बता
थोड़ा देखिए
देख लें
I just
सुनो थोड़ा सा देखिए गलत ऑर्डर मत कराइए
citation is 2008 volume 3 JCR 454
2008
volume 3 JCR just
454
454
ये तो होगा लिमिटेड टू क्रॉस एग्जामिनेशन
हाँ non-compliance of with order passed by court under section 15 defend of tenant struck off. Now tenant cannot defend eviction suit as a tenant, but he can contest the suit on question of right to the producing necessary evidence in that regard.
with what agency it will be a step up.
So maybe like I can cross examine.
Who तो क्रॉस एग्जामिन कर
ये वाला ये जजमेंट जो है ना 2008 का वॉल्यूम 3 JCR 450 उस पर है और कोई
454.
454
Or we spoke.
थोड़ा सा खोज लीजिए
If your litigation can post it on Monday.
हाँ
we
मंडे
can-
को नहीं हम इसको रखेंगे ट्यूसडे
Tuesday.
I will also try to
हाँ थोड़ा सा डाउट हो गया
Yeah.
मन में
नहीं
The learned counsel for the appellant is present. We have submitted that in spite of the fact that the defense was struck off, the learned courts have considered the evidence of the defendant to come to a finding of landlord-tenant relationship. He submits that under such circumstances only the evidence of the plaintiff could have been considered. He has relied upon the judgment passed by this court, report to 2008, redacted 3, that includes JCR 454, and has submitted that we shall go through the provision of law and also furnish more judgments for consideration. Let the judgments be furnished by the learned counsel for the appellant by Monday. Post this case on Tuesday.
Yes.
In supplementary list. It will come in supplementary list. थोड़ा बोलिए ठीक है थोड़ा 5-7 मिनट
Orders item 4 second appeal 334 of 2016.
Yes.
इस पे कॉस्ट जमा करने का ऑर्डर तो कर दिए थे रिसीट फाइल करना
अब क्या करना
कर
है
देंगे इसीलिए ऑर्डर
The case is already admitted by
Upon-
order 22.
अब लैंडलॉर्ड एंड टेनेंट
I am the landlord. I am the legal heir of the landlord. I am telling you. Final landlord, the plaintiff has died, my lord, during the pendency of the title suit. I was substituted, but that substitution was not reflected in the order sheet. Subsequently, my lord, the respondent herein has filed the appeal, my lord. That was decided in their favor. It is a matter of reversal, and I have challenged this also.
So एक ही substantial question of law करना है whether the legal heirs of the landlord can be treated as landlord claiming necessity of suit premises after the death of the original landlord. इसमें क्या है मरने के बाद personal necessity खत्म
नहीं judgment. But I am relying on Supreme Court judgments now. The personal necessity concept will, from the date when the suit was filed, the personal necessity, the case will be there. So honorable appellate तो judgments are there, my lord. I am guessing.
कौन सा judgment है judgment ले लीजिए please. देखिए ऐसे नंबर 334 of 2016
छोटा सा भी ये है कि ये जो लीगल हेयर बोल रहे हैं ये लीगल हेयर है ये प्रूफ ही नहीं हुआ
On that also I have
जो
judgments.
substantial question of law बना है ना उसके अलावा कुछ सुनने वाले नहीं है It is submitted that this case has been wrongly listed and money receipt in terms of order dated 16/7/24 has already been placed on record. Post this case for final disposal on Thursday. Judgment दीजिए दिखा दीजिए तो मुझे अपने से।
Item 5, second appeal 293 of 2017.
Yes, appellant. आइए, what आइए?
Item 5.
Yes, I know. Here I have filed an application under section 15 for deposit of the payment of rent. I am the landlord. My suit was dismissed and also they have not paid rent since.
When the suit and appeal is dismissed, what it is section 15 application, how will it lie at your end?
Yes, it is applicable at least.
No, but you see now the plea of eviction was on which ground?
On the ground of default or simplicity, the leadership have kindly, otherwise permit your leadership court can fix this for final hearing. I'm ready.
Or I can reply to the IA.
No.
It fix it for the final.
Thursday? With the consent of the learned counsel for the parties, let the matter be posted for final hearing on Thursday. And accordingly, the intermediary applications in the present case are not being pressed at this stage.
Only one.
Thursday.
Final disclosure.
Final discussion. And if you want it to ensure, please come at 10:30. Both of you will do it. कुछ इतना कभी एक मैटर बहुत लंबा चल जाता है तो ज़्यादा दिक्कत होता है। और बताइए।
Item 6, second appeal 024 of 2018.
Yes. क्या हुआ?
Notice is
किसको नोटिस भेजे?
If it may please your leadership, 1 week time may be granted to file wakalatnama. Instructions have been taken from respondent.
2018 का ये मैटर है। सब्सटेंशियल क्वेश्चन ऑफ लॉ बन गया है। बताइए। नहीं बना है ना?
लिमिटेशन
वो चलते ही जाएगा आपका 2016 से। अब कौन है? लैंडलॉर्ड है, टेनेंट है?
नहीं, हम टेनेंट
अभी तक इविक्शन नहीं हुआ आपका?
नहीं, एविक्शन ये हुआ यहाँ ये प्रॉपर्टी खास महल थी उसमें ये आया।
अभी आपका क्या काम है? सब्सटेंशियल क्वेश्चन ऑफ लॉ ही नहीं बना। अच्छा, लिमिटेशन किसकी तरफ से आपको मिला है?
Respondent number 2, your leadership.
रेस्पॉन्ड नंबर
2. We have just been received instructions. We haven't filed the wakalatnama yet.
जब केस टेकअप होता है तभी आपको इंस्ट्रक्शन मिलता है ना? 2023 में आपको नोटिस सर्व रखे रहिए वकालतनामा घर में फाइल के अंदर। Respond number 1 has expired. What have you done?
अब नो नॉलेज माय लर्नर फ्रेंड
No knowledge. ऑफिस नोट कौन पढ़ेगा?
और ये है
हम लोग को पर्सनल नॉलेज है क्या?
लीगल यस व्हाट द लीगल यस आई हैव नो नॉलेज दैट इज
And who is respond number 2? Is he related to respond number 1?
Yes, your leadership. He is related to respondent 1 and 3.
You give the details of the legal year. Maybe that they are already on record. But still, he has to file an appropriate application, isn't it? देखिए ऐसे नंबर 224 of 2018 में मिस्टर नाम बताइए अपना।
Arpan.
Mr. Arpan, advocate, undertakes to file wakalatnama on behalf of respondent number 2 within a period of 1 week from today. The office note reveals that respondent number 1 has expired, and so far as respondent number 3 is concerned, no such person is residing at the address. the record revealed that the proceeding has already abated against respondent number 1. So far as respondent number 3 is concerned, she appears to be close relative of respondent number 2. Respondent number 2. The learned counsel for the respondent number 2 is directed to provide the present and correct address of respondent number 3 within a period of 2 days from today. And upon receipt of the present and correct address of respondent number 3, the counsel for the appellant is directed to take steps for service of notice upon respondent number 3 at her present and correct address through speed post, for which requisites be filed within a period of 15 days thereafter. Post on
One more prayer.
2nd of September, awaiting service. Not 2nd September, it will come on 15th September.
One more prayer.
अब क्या?
If he supplies the legal name of legal years of the
अबेट कर गया प्रोसीडिंग. अब हम उनको कोई डायरेक्शन नहीं दे सकते.
Item 7, second appeal 278 of 2018.
क्या है इसमें?
On the last day, respondent number 1 to 3 notices were issued. It has returned the report that they don't reside in that
So?
address. Whereas we are in process of filing an IA for substituted service. Whereas I am saying that it may be posted next week, so that we may file an appropriate IA. The current address is of both parties.
You are the landlord or tenant? अभी तक होश नहीं आया है. हाँ? बिना फाइल के कैसे खड़े हो जाते? They have sold the property and went. क्या करेंगे आप? बताइए. I will just pass an order. You just hold on. SA number 278 of 2018. As per the notice, office note, the respondent number 1, 2, and 3 could not be served as they have sold the property and have relocated to some other place. The appellant is the tenant over the suit property, correct? Counsel for the appellant prays for time to take steps for substituted service of notice upon respondent number 1, 2, and 3, or to substituted service ही करेंगे ना, क्या करेंगे?
Substituted service. The current address that is given is of
Or to find out, or to take steps for service of notice upon respondent number 1 to 3 at their present and current address. Time for 1 week is granted to the appellant either to file a petition for substituted service of notice, to take appropriate steps, failing which this appeal shall stand rejected. Peremptory order. आएगा पार्टी तो कर दीजिएगा, नहीं तो स्पीड पोस्ट में आपको फाइल करना है. 1 हफ्ता में या वो फाइल कर दीजिए, आइए फाइल कर दीजिए फॉर सब्स्टिट्यूटेड सर्विस.
Item 8, second appeal 275 of 2019.
Yes.
This is an admitted second appeal. The question of law has been framed. On the last date, your notice was issued to respondent number 2 by both the process, you did file requisites, Your Lordship. There was a Dusty order also, Your Lordship.
Yes.
For pederasty to that, we not file the supplementary affidavit, Your Lordship.
So you want
It
right?
has-
The betting has already been given to us in a special proceeding.
Your Lordship,
I am the landlord.
pre-entry order may be passed in this also, Your Lordship. If
My lord, may kindly see this, my lord, the certified copy of the order.
the I was pending for
SA number 275 of 2019. As per the office note, the suit property has been executed, sealed, and delivery of possession has been handed over to the decree holder, namely Salil Kumar Datta, by the civil court. And consequently, the respondent number 2 could not be served. Counsel for the appellant prays for and is granted 1 week time to take fresh steps upon respondent number 2 at his fresh and his present and correct address, failing which this appeal shall stand dismissed without reference to the bench. This entire appeal shall stand dismissed without reference to the bench. ऐसा नहीं कि रेस्पॉन्ड नंबर 2 के अगेंस्ट में डिसमिस होगा, पूरा डिसमिस हो जाएगा। कोई यूज नहीं है ये सब केस का। There is no purpose. I have a meeting.
I was